Welcome, everybody. Very glad to see so many people. I think more will join in the next minutes, but we have a pretty short time to be together today. We have a lot of registration from all over Europe, from many professional organizations, public institutions, international agencies. Very glad to have you all here. My name is Pippo Costello. I'm the Director of Defense for Children Italy, and I will try to facilitate things. We have a very strong support from our technical assistants. As you know, you will have interpretation if you need it. There is just a button at the bottom of your screen. You can select the interpretation if needed. The meeting will be in English with interpretation, and some of our participants also will speak in other language, but you can find the facility on your Zoom screen. So thank you very much for being with us today. It's a very important event. It's important because it's an intermediate moment of an international process in the context of the initiative ECtHR, but also because we conceive this moment to contribute and to promote and eventually also inspire new theory and new action for the protection of children victims of crime on the basis of what is indicated and prescribed by international legislation. First of all, really thank you for the very important and guest that we are having today that will talk to us and will propose us different perspective on ways through which the standard should be understood and applied by states and by their public institution at all levels. It's really an honor and a pleasure to host a panel so meaningful and determined to promote the objective that brought us here today together. As I said, we have participants from many countries in Europe and beyond. We have, believe me, I mean, we feel a big responsibility in sharing in an optimal way the indication and the suggestion that will be proposed during this seminar. Just a couple of remarks, very shortly. I would like to propose you a couple of notes just to start with our seminar. From the analysis and action that we implemented in these years, we really realized that it's not possible to talk about adequate responses to children victims of crimes, if not in the context of an integrated, intersectional, systemic vision based on the principle and provision of the CRC. And I think that today some of our distinctive guests will talk about that. Despite the fact that we have this Convention on the Rights of the Child since more than 30 years, the best interest of the child is struggling to become the preeminent logic, the field of connection between mandates, disciplines, responsibility. And this difficulty is make hard to implement systems that are ready and effective, able to prevent, to protect, and also to respond to situations of violence involving children. In many cases, violence corresponds and is specular to structural situation of violation of the guarantees that should be applied from a public institution. There are still too many omission, lack of attention that is determining vulnerability to phenomena of violence and abuse on children. A lack of sensitivity, as I said, omission, and inappropriate condition of life are the context to which we have to refer to consider and face the specific situation of being victim of violence. And we have a lot of evidence on how an appropriate connection between low standard interdisciplinary theories, action and experience is the path to follow to give concrete responses, responses that are sustainable a long time. And yeah, we thought a lot about getting out from this simplified geometry that lead us to intend violence on children exclusively in the triangle aggressor, victim, and savior. Terror, horror, and pity are not enough to determine change. I'm sure that our guest will provide an articulate vision of what I just explained, and eventually I think that today's event will help in reinforcing our common context for understanding and action, promoting a new culture that can really be effective in preventing, protecting, and responding to violence following human rights and children's rights principles and provisions. As I said, just a few notes, but I would like to ask to start this day together our friend Isabella Mastropasqua. She's the director of Office 2 Juvenile and Community Justice Department of the Italian Ministry of Justice. She oversees the judicial social services throughout the 29 Italian judicial district. And she's a friend and a person who really connected theory and practice along the years. And so we are very glad to have you here. I know that you are traveling at the moment, so you found a place. We are very happy to have you with us today.
Okay. Buonasera a tutti.
Good evening.
Asking you to switch off to English because Isabella will talk in Italian, so you will have the interpretation in English of the words
Mi
of
dispiace,
Isabella
infatti parlerò in italiano.
Okay.
Buonasera a tutti. Sono qui.
Good evening, everyone. I'm here today on behalf of the Chief of the Department for Juvenile and Community Justice of the Ministry of Justice to show our concrete interest, the interest of the department about this topic, and especially about the issues of children that come into contact with our office. The law about sexual violence informs the intervention of the law enforcement when it comes to children victims of sexual violence. A challenge is the fact that today, even though we have this law, we have had this law since 1976, and even though our country has adopted the Directive 29 of the EU, there is still a challenge because sometimes the hearing of child victims of crime is still complex and the system is still varied and diverse in the various regions and cities. We have changed our constitution when it comes to regions, and therefore each region in Italy has its own procedures, and this leads to a non-cohesive approach in the national territory. And the operators that intervene in these cases are varied. The regional services, the health services, the judiciary, the health operators, and it's hard to work in a cohesive way. And our department wants to thank Defence for Children Italy that allowed us to handle these situations in a specific area, the city of Naples. We handled the complex interconnections between judiciary, law enforcement, and operators. And we are now building a possibility, an opportunity for concrete and actual cooperation to organize interventions so as not to leave any gap for the operators that have to handle these cases. It's a very complex work that is still ongoing. And we are collaborating in an optimal way with Defence for Children Italy, and we are building our best practices in our country, and I hope we will extend this not only in the Campania region, but also throughout the country. I'm very happy to listen to the distinguished speakers today. The next speaker will talk about the European Court of Human Rights, that for all of us is a safe haven for human rights, and because it allows the opportunity for people to access remedies and to highlight what doesn't work properly. Thank you all for this opportunity to grow together. And the floor goes back to people. Thank you.
Thank you very much. Thank you very much, Isabella. Thank you also for connecting with us while traveling. I think your words are coming loud and clear. And yeah, I'm suggesting, I mean, today we will have a lot of participants. It would be very difficult to have a discussion with so many people, but we would like to ask you if you have a question along the way. My colleague Daya Wenke will look at the chat. You can write question there, and eventually, if you really would like to intervene, let us know. If possible, we will give space to people that would like to say something directly. Thank you again, Isabella. It was very important to have you at the beginning of this day, and we have at the moment in our agenda, we are very happy to have President Robert Spano. He will talk about the right of child victims of crime in the case law of the European Court. A few words about President Spano. Robert Spano was elected to the European Court of Human Rights in 2013 with respect to Iceland, and is currently the president of the court. Before taking up his judicial office, he served as a parliamentary ombudsman of Iceland, and again in 2009, 2010, and again in 2013. He also served as the Dean of the Faculty of Law in the University of Iceland and was appointed Professor of Law in 2006. He was chairman of the Standing Committee of Experts in Criminal Law in the Icelandic Ministry of Justice from 2003 to 2009. He was also the Icelandic delegate to the European Committee on Crime Problems and an independent expert of the Lanzarote Committee of the Council of Europe. Judge Spano is a graduate of the University of Iceland and of the University of Oxford. President Spano, we are very happy to have you here, and you have the floor. Thank you very much.
Grazie mille, signor Costella. Comincio in italiano un po' perché voglio utilizzare un po' le mie origini italiane.
But you have to unmute yourself.
I'm extremely happy to be able to be with you here today. As President of the European Court of Human Rights, talking about issues of children's rights is both an honor and a duty. I have recently spoken at 2 events dedicated specifically to the rights of children. In October 2021, I had the pleasure of participating in an exchange of views with the Council of Europe's Committee on Protection of Children Against Sexual Exploitation and Sexual Abuse, which you all, of course, know as the Lanzarote Committee. And in April of this year, during the high-level launching conference of the Council of Europe Strategy for the Rights of the Child, I gave a presentation on the role of the ECtHR in strengthening the rights of children. Now, the jurisprudence of the European Court of Human Rights has developed significantly since the convention was drafted roughly 70 years ago. Indeed, it is surprising that when we learn that the convention itself contains only 2 explicit references to children, in Article 5 of Protocol number 7 on the equality between spouses, and over the last decades, however, the court has developed to take into account a more child-centered, more humane approach to human rights. It is no longer in doubt, and I think this is an important element for the overall debate when we talk about children's rights, that children are themselves holders of rights rather than simply objects of protection. Indeed, the court has developed a rich and extensive body of case law concerning the rights of the child. This case law covers family-centered issues such as custody and access rights, as well as child adoption. It also covers domestic violence, sexual exploitation, and fair trial guarantees. As I mentioned during the 2 conferences that I alluded to a moment ago, it is a sad reality that cases involving criminal acts against children are nothing new. They have been lodged and dealt with by the court since its early beginnings, where the court found that children and other vulnerable individuals are entitled to effective protection by the state. Complaints involving violence against children have therefore arisen before the court in a variety of settings, such as within family, in care homes, at school, or in churches. Many such cases are examined under Article 3, prohibition against inhuman and degrading treatment and torture, and Article 8, the right to private and family life of the Convention. Both these articles entail an obligation on the state to safeguard the physical and psychological integrity of persons. However, in recent years, the court has outlined contracting states' responsibilities towards the victims of child trafficking. Such cases are examined under Article 4 of the Convention. Under the court's jurisprudence, states' obligations towards child victims of crime are threefold. Firstly, they must put in place a legislative and regulatory framework of protection. Secondly, in certain well-defined circumstances, there is an obligation to take operational measures to protect specific individuals against a risk of treatment contrary to the Convention. And thirdly, states' authorities must carry out an effective investigation into arguable claims of inhuman treatment. However, the court's case law makes it clear that the positive obligation of protection assumes particular importance in the context of the provision of an important public service, such as primary education, where state authorities are obliged to protect the health and well-being of young children who are especially vulnerable. Moreover, the duties owed under the Convention will be construed in the light of international instruments such as the Lanzarote Convention and the Council of Europe Convention on Action Against Trafficking in Human Beings. So what I want to do now, if you allow me, I want to structure my following remarks into 4 parts. Firstly, I want to elaborate on the duty to place an effective regulatory framework. Secondly, I will want to look at the duty to conduct an effective investigation. Thirdly, I want to examine how the court relies on other international instruments in its reasoning within the context of a case on trafficking in human beings. And finally, I will look at the challenge of new technologies. But before I start, I want to make the following general thematic point very clear. The life of a child within the context of the convention is a life which has an underlying protective scope of human dignity. It is clear that children as human beings, as I mentioned before, are not simply objects of protection to satisfy the rights, the hopes, the interests of others. In particular, other family members, parents, and so forth. The law has developed to take into account the child as such, as an autonomous human being in a state of vulnerability at the outset of its life, in which human rights protections have to be all-encompassing and take in particular account of the specific situation and the maturity and development of a child. Now, why do I say this at the outset? It is because this is a marked development from the inception of the convention. If we were having a conference on children's rights in the 1950s and 60s, firstly, we probably wouldn't have had such a conference because the rights of the child were not front and center in any rights debate. On the contrary, there was a lot of lack of observance and understanding of the particular vulnerabilities of children. History has told us what has happened. So we have moved very far in the last 30 to 40 years, and in the last 10 to 20 years, even further. And it is a great achievement. And it is achievement in which the European Court of Human Rights and the European Convention have been a part of. Now, let me first move to the framework duty, the first of the 4 duties that I intend to talk about. This duty entails an obligation on states to establish a legislative and regulatory framework to shield individuals adequately from breaches of their physical and psychological integrity, particularly in the most serious cases, through the enactment of criminal law provisions and their effective application in practice. In the context of child sexual abuse, particularly in cases where the potential abuser is in a position of authority over the child, the existence of useful detection and reporting mechanisms are fundamental to the effective implementation of the relevant criminal laws. The importance of such mechanisms were illustrated in the case, the famous case, the landmark Grand Chamber judgment in the case of O'Keefe versus Ireland. In that case, it had been undisputed that during the first 6 months of 1973, the applicant had suffered 20 sexual assaults at the hands of a school teacher in a state-funded national school owned and managed by the Catholic Church. The court found that by 1973, the Irish authorities had been aware of the level of sexual crime by adults against minors. A number of reports from the 1930s to the 1970s gave detailed statistical evidence on the prosecution rates in Ireland for sexual offenses against children. Therefore, when relinquishing control of the education of the vast majority of young children to non-state actors, in this case, the Catholic Church, the state should have also been aware of potential risks to their safety if there was no appropriate framework of protection. However, none of the measures the government had put in place during the relevant period provided effective mechanisms for the detection and reporting of any ill treatment. Indeed, the national rules and guidance for church-run schools did not refer to any obligation on a state authority to monitor a teacher's treatment of children or provide a procedure for prompting children or parents to complain about ill treatment directly to the state. Before the court, the government referred to a system of school inspectors. However, This system placed no obligation on the inspectors to inquire into or monitor a teacher's treatment of children. Rather, their task was principally to supervise and report on the quality of teaching and academic performance. The legal framework in place indeed had allowed over 400 incidents of abuse to occur over a substantial period of time. And in these circumstances, the court concluded that the mechanism for detection and reporting had been ineffective and found a violation of the substantive aspect of Article 3 of the Convention. Allow me, before I turn to the investigative duty, to mention, of course, because we have with us Mr. Bragi Guđbrandsson, my good friend and colleague from Iceland, who, of course, is an eminent figure in this field with decades of experience when it comes to children's rights. We, of course, went through in Iceland a period, and I took a direct part in the investigation of neglect and abuse of children in state-run and municipally run schools and centers for children from 1947 to 1992. So even though O'Keefe versus Ireland focuses on a particular situation in the 1970s in Ireland, by no means is this an isolated incident. It is clear that in most of our states, if not all, children in the 1950s, 60s, 70s, and 80s, they were not in a protective environment when they were within state-run or municipally run institutions. As I said, we have examples of that from my own country, and I'm sure Bragi can tell you even more about that later on. The second is the investigative duty, which requires states on receipt of arguable complaints of ill treatment and other criminal acts to conduct an effective official investigation to establish the facts of the case and identify, if appropriate, punish those responsible. This investigation must fulfill a number of criteria. It must be sufficiently thorough. The authorities must take reasonable measures available to them to obtain evidence relating to the offense in question. A serious attempt must be made to find out what happened, and authorities should not rely on hasty or ill-founded conclusions to close their investigation. Any deficiency in the investigation which undermines its ability to establish the facts or the identity of the persons responsible will risk falling foul of the convention. Finally, a requirement of promptness and reasonable expedition is also implicit in the obligation to carry out an investigation. To illustrate how this duty applies in practice, I shall refer to the facts of two cases. Firstly, let me talk about X and others versus Bulgaria, a Grand Chamber judgment of February 2021. The circumstances of this case, as in many cases of this nature, are harrowing. The applicants, who were 3 siblings, were born and raised in an orphanage in Bulgaria. Subsequently, they were adopted by an Italian couple. Whilst resident in Italy, however, they revealed to their adoptive parents allegations of severe sexual abuse at the hands of orphanage workers during their time in Bulgaria. With the help of an NGO, the parents lodged complaints to the Italian authorities, who subsequently transferred the allegations to their Bulgarian counterparts. On finding a violation of the procedural limit under Article 3, the court identified a number of flaws in the investigation. In view of the nature and seriousness of the alleged abuse, the court took the view that proportionate and necessary investigative measures of a more covert nature, such as surveillance, should have been considered. In view of these shortcomings, the court held that the investigating authorities had not taken all reasonable measures to shed light on the facts of the case. Such omissions appeared sufficiently serious for the court to conclude that the investigation carried out was not effective for the purposes of Article 3 of the Convention. Findings of procedural shortcomings were also made in the case of NC versus Turkey of 2021 as well. This time, however, the court focused on the failure to protect the applicant's personal integrity in the course of the criminal proceedings opened up against the perpetrators. The case concerned a 12-year-old child who had been forced to work as a prostitute by 2 women. she lodged criminal complaints against both the women and the men with whom she had had sexual relations. The court found that the proceedings had been flawed in numerous respects. For 18 months after her complaint had been lodged, the applicant was at no point supported by a welfare assistant, a psychologist, or any kind of expert, either before the police or the prosecutor, or during the hearings before the Assize Court. This was in spite of the fact that various international instruments on the protection of victims of physical violence outlined the kind of assistance that should be provided to child victims of sexual abuse and exploitation. During the criminal proceedings, she had been placed opposite the defendants and was obliged to recount in detail the assaults, the threats, and rapes of which she had been a victim, creating an extremely intimidating environment for her. The applicant had also been subjected to countless court-ordered medical examinations, which had been excessive and therefore, according to the court, constituted an unacceptable interference with the applicant's physical and psychological integrity. At the close of the hearings, the applicant had also been required to confront the aggressive attitude of the defendant's relatives, to the extent that on one occasion, a police escort had been necessary to enable her to leave the town. As a result, the national authorities' conduct had not been compatible with the obligation to protect a child who had been the victim of sexual exploitation and abuse. Accordingly, there had been a violation of Articles 3 and 8 of the Convention. Here, let me turn to the third duty, how the court has recourse to international instruments in defining the scope of states' duties. And I would like to give an example of trafficking in human beings. It is now well established that both national and transnational trafficking in human beings, irrespective of whether or not it's connected with organized crime, falls within the scope of Article 4 of the Convention. Article 4 may in certain circumstances require a state to take operational measures to protect victims of trafficking where state authorities are aware or ought to have been aware of circumstances giving rise to a credible suspicion that an identified individual had been trafficked within the meaning of Article 3A of the Palermo Protocol and Article 4A of the Council of Europe Convention on Actions Against Trafficking in Human Beings, known as the Anti-Trafficking Convention. The case of VCL and AN versus the United Kingdom as an example of how such treaties have been used by this court to identify the content states' duties under Article 4. In this case, the applicants were Vietnamese minors who had been charged by the UK authorities with being concerned in the production of a controlled drug. However, there were numerous indications that they had been trafficked. Both had been found in cannabis factories in circumstances which themselves had given rise to a credible suspicion of trafficking. Concerns had been raised both by an NGO and social services that they were potential victims of trafficking. Indeed, the prosecution's own guidance identified Vietnamese minors as a category particularly vulnerable to that crime. Despite these circumstances, however, neither the applicants had been referred immediately to the competent authority for a trafficking assessment, but had been instead charged with criminal offenses to which they had later pleaded guilty. The CPS, which is the Crown Prosecution Service in the United Kingdom, had also failed to give sufficient reasoning, which was consistent with the definition of trafficking contained in the Palermo Protocol and the Anti-Trafficking Convention for prosecuting the applicants. This case is particularly noteworthy for being the first occasion in which the court had been called upon to consider if and when a prosecution of potential child victims of trafficking may raise an issue under Article 4 of the Convention. The court held that no general prohibition on the prosecution of victims of trafficking can be construed from the Anti-Trafficking Convention or any other international instrument. However, any decision on whether or not to prosecute a potential victim of trafficking should, insofar as possible, only be taken once a trafficking assessment has been made by a qualified person. That assessment should be based on the criteria identified in the Palermo Protocol and the Anti-Trafficking Convention, i.e. the investigation should establish whether the person was subject to the act of recruitment, transportation, transfer, harboring, or receipt by means of threat of force or other form of coercion for the purpose of exploitation. Given their inherent vulnerability, the threat of force and or coercion is not required where the alleged victim is a child. In the circumstances of the case at issue, the court held that the United Kingdom had not fulfilled its duty under Article 4 to take operational measures to protect the applicants as potential victims of trafficking. Allow me then to turn to a field which is becoming ever more important for the health and welfare of children, their safety in cyberspace. We all know that digital safety is of the utmost importance, especially to children. Already as early as 2008, the court dealt with the theme of protecting children from being targeted by pedophiles on the internet. The landmark judgment of the court, and often discussed, is of course the case of KU versus Finland. The applicant, a minor aged 12 years at the time, was the subject of an advertisement of a sexual nature on an internet dating site. The identity of the person who had placed the advertisement could not, however, be obtained from the internet service provider due to the legislation in place at the time. The court noted that sexual abuse is unquestionably an abhorrent type of wrongdoing with debilitating effects on its victims. Children and other vulnerable individuals are entitled to state protection in the form of effective deterrence from such grave types of interference with essential aspects of their private lives. Now remember, KU versus Finland is now 14 years old. And what has happened in cyberspace during that time, we all are aware of. The dangers that are fraught with children on websites, on the internet, have exponentially increased since 2008. Indeed, in a more recent case, Trabajo Rueda versus Spain of 2017, we dealt with the issue of online pornography of children, but from the perspective of a man whose computer was seized on the grounds of the material contained therein. The court has not as yet had an opportunity to deal with cyberbullying in respect of children, which is an incredibly dangerous and important phenomenon. However, it is noteworthy to mention that in Buturuga versus Romania from 2020, the court found that the Romanian authorities had failed to respond to a woman's complaints of domestic violence and cyberbullying by her former husband. On that occasion, the court pointed out that cyberbullying was recognized as an aspect of violence against women and girls, and that it could take on a variety of forms, including cyber breaches of privacy, intrusion into the victim's computer, and the capture, sharing, and manipulation of data and images, including private data. So, ladies and gentlemen, dear colleagues, let me then enter my conclusion. If one looks at the trajectory of the court's jurisprudence over the last years, one can see that the court now treats children, as I mentioned, as independent beneficiaries of the rights guaranteed by the convention. And the court has clarified the scope of states' duties towards child victims in a variety of contexts, from publicly run institutions to acts committed in the home by private actors. Moreover, the court's jurisprudence in this sphere is constantly developing in light of new challenges, as I've just shown. I have no doubt that the European Convention, as a living instrument, remains well equipped to respond to these new challenges. As a former expert to the Lanzarote Commission, let me make absolutely clear my view, which transpires from the court's case law, that the Lanzarote Convention has become one of the essential frameworks of assessment for the work of the court, and it must continue to do so. That is why conferences like these, people like you that are listening, that are taking part in the defense of children's rights every day, that have given their lives to the protection of children, are an absolutely crucial element for the ongoing development in this field. A robust debate, a critical debate about the evolution of children's rights and the way we can together find a way of creating a framework, an understanding, awareness, education, knowledge that allows us every day to better the lives of children is probably one of the most pressing issues of the modern era. Thank you very much, Mr. Costella. Thank you very much for having me on this afternoon, and I would welcome some questions. I will have to leave you in about 15 minutes, but would be happy to take some questions. Thank you very much indeed.
Thank you very much, President Spano. Very precise, very, lot of elements from what you are proposing us, integration, construction of vulnerability. I mean, a kind of a very extensive responsibility and understanding needed in order to be specific and apply the rule of law in an intelligent and effective way. I will ask my colleague Daya Venke, who is monitoring the chat, if we have any questions or items raised by our participants. Daya, you have the floor.
Thank you very much. And thank you, President Spano, for this most enlightening speech. It's been a great pleasure to listen to you. I would like to bring to your attention a question from Raul Alexandru Nestor that I see in the chat. And this relates specifically to the scenarios that you described where the court observes or finds omissions by states in safeguarding and securing the rights of the child victim in the context of investigations and proceedings. And I imagine this is a particularly challenging activity of the court to identify these omissions. Mr. Nestor is describing a situation where, and I believe he's joining us from Romania, he's describing a situation where children receive legal aid, and this has a consequence in that the child is assisted by one lawyer during the investigations, a different lawyer during the first trial, and if the case goes to the appeal, yet another lawyer. Mr. Nestor is asking if this would amount to an omission by a state in not ensuring the continuity in the legal representation for the child.
Well, I can't answer that directly by referring to cases from the court because I don't think we have ever answered that question. Now, I would be surprised that if legal representation at every stage of the proceedings is effective, that we would here go so far as to say that not securing the same legal representation throughout would constitute a violation of the convention. I mean, let me say that as a general answer. And of course, it all has to depend on the facts. Because remember, in child proceedings, we may actually have stages where different types of legal knowledge are required. So you could have an initial stage of a case where you would need legal assistance of a particular type. And when you come to trial, you would need a different type of lawyer to be able to litigate a case before a court. So actually, there may be a need in having some change of representation. But of course, ideally, it would be best that the child is not subjected to frequent changes of those assisting throughout the proceedings. But overall, I think what we are requiring is that the assistance given at any given time is effective. Now, whether it is the same person is not potentially or necessarily the most important aspect, so long as the underlying assistance given is effective.
Thank you. I think that the questions are floating in the chat. So Daya, would you like to?
Thank you very much, President Spano, for this response. I see also Mr. Nestor thanks you for the comprehensive answer. We have maybe a similar or related question from Margaret Tweet regarding reporting obligations, if I understand this correctly, as states take very different approaches in child safeguarding measures and obligations to safeguard children in the context of violence. And Ms. Tweet is asking if you could kindly share with us your views or on the court's views regarding such mandatory reporting obligations, and if the absence of such reporting obligations could possibly also be interpreted by the court as an omission.
I think there we have to make a clear distinction between reporting obligations directed at a private person and reporting obligations imposed on public servants. That's the first legal distinction we have to make. It's clear that in many or even most of our states, there is actually a reporting obligation, which is a general one. It can apply to private persons and public persons, potentially with the exception of some family members. But even we have reporting obligations that are extensive. For the purposes of the convention, the most important element is if a state agent, and when I use the word state agent, it applies to every possible public person, public servant, has knowledge of ongoing child sexual abuse, for example. And we have this standard of knowledge the person knows, or what we call constructive knowledge, the person ought to have known. That triggers a duty to take measures. And that one of those duties could be a reporting obligation, to let it be known. For example, the classical scenario are teachers or, potentially members of the medical profession and issues like that. So because the convention is directed at the state and is requiring the state to act, a reporting obligation, which either is not in place or is not effectively implemented, can, yes, lead to a violation of the convention. In those circumstances where a public servant who has knowledge or has constructive knowledge of ongoing violence or harm to a child does not act on the basis of that knowledge according to the procedures required, that could be the basis of a violation, yes.
Thank you, President Spano. Najat, do we have other, I think there is another question.
Yes, people, here's one more question from Konstantina Karamitzi regarding the citizenship, right to citizenship and the situation of stateless children. And she is asking if the court has ever dealt with cases of stateless children and what could be the views of the court regarding a right to citizenship.
Now, that is a very, very tricky question. The first answer that I would give, that under the convention, there is no direct right to acquire citizenship. There is no convention provision which directly grants a person the right of citizenship. However, as you are aware, under international law, there are various rights of stateless persons. States have a duty to secure the rights of those within their jurisdiction that are stateless. So, for example, a state is prohibited from expelling a stateless person. Now, what this means is that under Article 8, the right to privacy and family life, and potentially under Article 3 of the Convention, the prohibition against ill treatment or putting a person in a precarious situation, these provisions have been interpreted to mean that when a state is dealing with a person that is stateless, it has to guarantee that person's situation and create legal safeguards for that person domestically. But that does not necessarily have to lead to that under the convention there is a right to obtain citizenship. However, under international law, on the rights of stateless persons, there are various rights which the court has incorporated through the convention provisions in question. And that, of course, applies to children even more than others, as you can imagine.
Thank you, President. Do we have a last question, just to exploit your presence up till the end?
I do not see anything in the chat. If I may, I will have a question regarding this very inspiring practice of the court to interpret the existing conventions, which often date decades back, in light of the evolving standards, especially looking, of course, at the policy instruments that the Council of Europe develops, but also the evolving situation of childhood and society. I wonder if you have any recommendations for national judiciaries and how they could achieve a similar approach in continuously interpreting existing international standards in light of the changing world and the changing reality of the persons. Thank you.
Well, indeed, when a state is a member state of the Council of Europe, as we now have 47 European states, as you are aware, on the 16th of September, Russia will leave the convention system for obvious reasons that we all know about. But the other states that will remain, national judges are under an obligation to take into account the case law of the European Court of Human Rights. And so to some extent, through that international law obligation, they need to adapt their interpretive methodologies to the same type of interpretive methodologies that transpire from our case law. So when they see, take an example, the way in which the court has developed since the Convention on the Rights of the Child from 1989 became the overarching international instrument about the rights of children, and we have incorporated that convention into our analysis of children's rights. For example, by making the child's best interest the primordial overarching principle which permeates our jurisprudence, that of course requires national courts to do the job in the same way. So I think in our work, we are constantly in dialogue with the national judiciaries, trying to persuade them that the best way for them to be able to respect the requirements of the convention, which they have to do because their states are member states of the Council of Europe and the convention, it is to integrate the kind of methodologies that we use in their own practice.
Very well. I think we have a still very last question from Mr. Mark Riebe, saying Switzerland is still allowed to beat your children and there is no fine for it. Do you know why? And there are still money fines where if you own or distribute child pornography or abuse children.
No, that is a question for a Swiss lawyer. I cannot answer that question, I'm afraid.
Very well. I think I would like to thank you again, President Spano, for your very precise and inspiring, intervention. We are really very glad to have you here. I think you contributed a lot to this event in a very practical sense. There are a lot of implications on what you said, and we surely will reflect on the suggestion you provided us. And we will make sure to let you have also the other interventions since you have to leave now for other commitments. So thank you again from Defense for Children and all the organizers here. We are very inspired and, confident of the court. The fact that you are there, it's for us really a very important reference. So
thank you very much. Thank you very much indeed. And let me just say what a pleasure it is that you pass from one Icelander to another. Have a nice day. Thank you very much.
Thank you very much again. Bye.
Same to you. Thank you, Robert. Thank you so much.
Yes, in fact, now we have, after this framework proposed by President Spano, we have Mr. Bragi Guđbrandsson explaining us the European Court of Human Rights case law and the potential impact on the new NCRC monitoring role. Mr. Bragi Guđbrandsson is currently an elected member of the United Nations Committee on the Rights of the Child since 2019. He is a former Director General of the Icelandic Government Agency for Child Protection from 1995 to 2018. He is a former chair of the Council of Europe Lanzarote Committee. Is a member of the expert group that drafted the Lanzarote Convention and the Council of Europe guidelines for child-friendly justice. He is a pioneer in the establishment of Barnahus, Children's House in Iceland in 1998, a child-friendly and multi-agency intervention to respond to child sexual abuse. Honorary founding member of the Promise Project for implementing the Barnahus model in numerous European countries. Thank you very much. Very, very happy again to have you here, Mr. Guđbrandsson, and you have the floor to inspire us. Thank you.
Thank you very much, Mr. Costella. Buongiorno. I have to say some Italian following my friend Spano. I am very honored by your invitation to speak to you today. And following the presentation of this wonderful presentation of Robert Spano, it's a great challenge to address this topic. So without further ado, I will try to share with you my PowerPoint presentation. Let us see if I can get it here on the screen. While it's coming up, I just want to say that I admire very much the progress made by the court under the presidency of Mr. Spano. It has been a wonderful journey. Unfortunately, Mr. Spano won't be there forever, but I hope that his successors will work in the same spirit. Now, my presentation will be on the court case law and the potential, I put it in bracket, impact on the Committee on the Rights of the Child monitoring role, or jurisprudence, if you like. And I put potential in brackets because I believe that already the case law of the courts of the human rights has impacted the decisions of the committee very profoundly. Now, just to give you an overview of my presentation, I will first start off with a few remarks on the shortcomings of the traditional approach of dealing with child abuse in the European justice system. I will say a few words on Barnahus because I never opened my mouth in international forum without talking a little bit about Barnahus. Barnahus is an attempt to balance the human rights principles of the fair trial in the best interest of the child. I will then speak about the committee and on European law and monitoring work of the Committee on the Rights of the Child. And finally, I will look at the recent judgments of the court and the potential impact on jurisprudence of the Committee on the Rights of the Child. Now, first, general remark on the justice system in Europe. We know that traditionally the real object of the justice system is to determine on guilt or innocent, and if the accused person is determined guilty, to determine the punishment of the perpetrator. We have in Europe distinct justice systems, including the role of judges and prosecutors, exposing evidence in court. the inquisitorial, adversarial systems. But both justice systems are committed to the principle of the due process or the fair trial, but not necessarily the best interest of the child. That's not an overall objective of the justice system. Now, the concept of due process or the fair trial consists of two basic principles. On the one hand, you have the principle of evidentiary immediacy, which means that the evidence, including state witnesses, must be presented directly in front of the court, the judge or the jury, as the case may be. So the judge needs to be able to see and hear the evidence and sense the evidence directly without any intermediary. And secondly, we have the principle of equality of arms, which basically means that the accused person must have the opportunity to contradict the case of the prosecution against him and provide for alternative explanation. Now, if you take these principles to the extreme, you will have a scenario in the courtroom pretty much like you see in this picture. This picture is in fact a reality. It's used to prepare children for performing their witness obligation in the courtroom. It's from Moldova. Moldova, in fact, opened the first Barnahus last month. So I don't know if it's still applicable, but you can see this is a scenario which is quite clear. You have the prosecution to the left and the defense on the right, debating the case under the auspice of the court judge, and sort of the child being a witness there in the middle of this fire. Now, this, of course, is not. This is, of course, very harmful, or can have very harmful impact on the child witness, as the child is subjected to cross-examination, even face-to-face with the accused in the court setting. And all the instruments of the Council of Europe that we will be dealing with, like the Guidelines on Child-Friendly Justice, the Lanzarote Convention, and the case law of the court, it really goes, it's all focused on sort of introducing some sort of measures protective measures to mitigate the harmful effect on the child victims in this scenario. Now, what are these adversities for children in the justice system? Now, first, we are talking about multiple interviews in different locations and the corresponding re-traumatization of child victims. We must remember that child abuse, and particularly child sexual abuse, is not only a judicial issue, it's also a child protection issue. It's a health issue concerning both mental health and physical health of the child. So all these professionals need to learn the child's disclosure to be able to perform their function. And then you have the interviews necessary for the justice system. And this, if nothing is done to mitigate this, what adds very much to the traumatic experience of the child victims. But furthermore, it contaminates and reduces the evidentiary validity of the child's narrative. And this is one of the basic reasons why it is so difficult to conclude these cases in the justice system. And the second category of adversities relate to the waiting for the trials with one or more appeals. That puts the child victim at halt and constant distress due to very paradoxical messages. On the one hand, the child is told to continue with his or her life, forget about the abuse, do the work in school, etc. But on the other, they get the message that they must remember every detail to be able to explain this for the judge during court process when that takes place even years after the abusive event. And finally, you got this hostile cross-examination in the courtroom intimidating, degrading, and traumatic to the child witness, often in a language incomprehensible to the child. Now, Barnahus is designed to address these judicial adversities for children, as it is meant to harmonize the principles embodied in the United Nations Convention on the Rights of the Child on the one hand, and the human rights principle of due process of fair trial on the other. A child-friendly arrangement for eliciting the child narratives at the investigative states or pre-trial states, enhancing the evidentiary validity of the child testimony, avoiding unduly delay, and applying evidence-based interview, applying only trained interviews. And very importantly, by audiovisual recording of the child's testimony with the aim of avoiding repeated questionings during the court hearing. But these must be done under the conditions required to ensure fair trial, that is, by the representation of the defense and allowing for cross-examination. That is the principle of the equality of arm. Now, Barnahus was inspired and is based on the Convention on the Rights of the Child guiding principle, particularly Article 3.1 on the best interest of the child, and Article 12.2, which embodies the rights of the child to be heard in all judicial and administrative proceedings. Of course, the Convention is the basis for the Committee on the Rights of the Child's monitoring obligations on state parties. And in this procedures, the committee is very much focused on Article 19, which puts the obligation of the state to protect the child from all forms of physical or mental violence, including injury or abuse, including sexual abuse. And Article 34, that focuses particularly on child sexual abuse and sexual exploitation. And in the interpretive opinion of the committee, in General Committee 13, on the right to freedom from all forms of violence, these obligations are further elaborated in terms of, for example, investigation, the approach as well, that should be child rights-based, child-sensitive, and et cetera, et cetera. So it sort of elaborates on that part of the state's obligation, the procedural part that President Spano discussed in his presentation. Now, there are other UN standards. For example, the UN Guidelines in Justice in Matters Involving Child Victims and Witnesses from 2009, where inter alia, by way of it's emphasized that videotaped examination of child witnesses prior to the main hearing, in which case the counsel for the accused may attend, is highlighted. And the ECOSOC resolution in matters involving child victims and witnesses of crime from 2005 was very interestingly emphasizes the use of child-sensitive procedures, including interview rooms designed for children, interdisciplinary services for child victims integrated into the same location. These are examples of the standards that the Committee on the Rights of the Child is applying its monitoring role. Now, the Committee on the Rights of the Child does not incorporate regional instruments, case law, into its jurisprudence or its decisions overtly or explicitly. However, European laws, particularly the treaties, conventions, or directives, the key policy documents like the Guidelines on Child-Friendly Justice, and of course the case law of the Court of Human Rights and the European Court of Justice are source of inspiration for the Committee on the Rights of the Child in their monitoring business. Now, particularly, I should like to highlight the Lanzarote Convention. Now, President Spano has already explained how important the Lanzarote Convention is in this context, and I can for sure say that the Lanzarote Convention has had an impact, very important impact, on the jurisprudence of the Committee on the Rights of the Child during the past years, as I will highlight. and particularly the emphasis of the Convention on multi-agency, comprehensive and child-friendly interventions. Furthermore, the emphasis on interviews with children and elaboration in the convention, Lanzarote Convention, with regard to proper conduct of interviews with child victims has very much affected the committee's work in dealing with the state monitoring. Now, this same can be said with Council of Europe guidelines for child-friendly justice. They contain extremely important principles in this respect, and particularly that it advocates for less strict rules on giving evidence, which I will say a few more words about a little bit later on. Now, already when we talk about the possible impact of the case law of the Court of Human Rights and the courts of European Court of Justice on the jurisprudence of the Committee on the Rights of the Child, well, there are, of course, certain case laws that have had a extremely important impact on the committee, but rather more on the European law than the committee. So it sort of travels from the court cases to the European law through the standard setting of the Council of Europe, followed by the standard setting of the European Union. That is normally what we see, and in particularly the earlier cases of the court, like for example, SN versus Sweden from July 2002, where it was established that video recording of the child's statement accepted as evidence prior to the court proceedings is perfectly viable procedure in dealing with this, and provided it allows for the accused person to exercise its rights on equality of arms by cross-examination of the child. Now, the European Court of Justice, the Luxembourg Court, in fact, in an Italian case from 2005 to 16th of July 2005, also came to the same conclusion that national courts must allow child victims to testify in a way that guarantees protection, for example, outside the trial and before it takes place. And there are more case laws that are extremely important, have greatly impacted European law, and in particularly the standards that Council of Europe has set, like the guidelines on child-friendly justice and the Lanzarote Convention. And of course, the good practices like Barnahus. Now, last year, the European Court of Human Rights passed two landmark judgments that are, in my view, going to have a great impact on children's rights and its development in the coming years. And for the first time, to the best of my knowledge, in these judgments, an explicit application was made of international, and particularly European law, with detailed argumentation applying the principle of the Lanzarote Convention, as well as the non-binding instruments, such as the Council of Europe guidelines on child-friendly justice. So this is a breaking news in my view, really, that how these standards are used in a systematic and concise manner by the court in the argumentation of a judgment. And these judgments that I will argue that have already impacted the jurisprudence on the Committee on the Rights of the Child. Perhaps not in the substantive issues that these two judgments are addressed, but rather in terms of the general approach that the court is applying less strict procedural rules for children's testimony than hitherto have been applied. And that means that it sort of it is a message to the states that they have to take measures to mitigate the adversive experiences of children. They have to make arrangements to ensure their protection and avoid re-traumatization of children in court proceedings. And therefore, I believe it will greatly impact national states as well as the Committee on the Rights of the Child in the coming year. Now, we have seen new themes in the jurisprudence of the Committee on the Rights of the Child development in the recent years, whereby the principles of the Lanzarote Convention are introduced in the monitoring decisions. The emphasis on intersectoral, multi-agency, and interdisciplinary interventions. The emphasis on child-friendly investigation, forensic interviews. Emphasis on child-friendly facilities and environment for interviewing children. Avoiding secondary victimization or re-traumatization by repetitive interviews. To ensure appropriate trauma-focused therapy, comprehensive support, and effective remedies for child victims. And, very importantly, explicit recommendations on Barnahus as a feasible model to respond to child sexual abuse and sexual exploitation. All of these new developments of the Committee on the Rights of the Child. However, there are still new developments. And during this session that is just over, was over on 4th of June, the committee applied for the first time new methods in its jurisprudence in dealing with 4 states that all of them had in common that they demand children to give their testimony during court procedures in one way or another. And the committee is saying, would you consider changing these practices? And the first case I want to mention is Cyprus. Cyprus has a children's house, this child-friendly multi-agency facility to take the children's testimony. And the testimony is audio-visually recorded without delay, and it is allowed as evidence in chief during court proceedings. However, the child may also need to give witness to the court during the court procedure. And as a rule, the child needs to be cross-examined during the court hearings if that is required by the defense. So the recommendation here of the committee is very clear. Stop these practices, introduce the principle of the equality of arm into the pre-stage phase by allowing the questioning to take place in the children's house, record this and submit it to the court. And the second similar jurisprudence on behalf of the committee was in Croatia, also from last month. In Croatia, they do not have Barnahus, but they have a child-friendly and multi-sectoral approach, at least in Zagreb. And they have been for a long time. There's a tradition of child-friendly approaches. However, children need to give their testimony during the court procedures. And again, the committee is quite clear there in this message. Consider as a standard procedures the acceptance of audio visual recordings of the child testimony as the main evidence for cross-examination without delay in child-friendly facilities. This is a very similar recommendation as to Cyprus. In concluding observations of the Committee on Canada, also last month, it's the same. In Canada, they do have multi-agency and child-friendly child and youth advocacy centers, but children, as a rule, they need to give their testimony during the court proceedings. And the committee conveys this message. Considered as a standard procedures, the acceptance of audiovisual recordings of the child's testimony as evidence in chief, followed by cross-examination without delay in child-friendly facilities. And Chile, final state that this was addressed particularly, it's virtually the same word. The message of the committee to the state of Chile is this: set up the standard procedure as to accept the audiovisual recordings of the child testimony and allow that as evidence, followed by cross-examination without delay in a child-friendly facility. So it's quite clear that the committee is now introducing a new jurisprudence, and I think it is inspired by these two recent judgments of the European Court of Human Rights that I mentioned. And my final slides is on the progress in child-friendly justice. And it is so important to realize the dynamic we are witnessing in child-friendly justice over these recent years, which is ongoing. And there are many actors, and there are, so of course, the convention, the committee. It's good practices like Barnahus and proliferation of Barnahus. It's, of course, the Council of Europe and the European Union instruments. There's the impact it has on national legislation, and very important, the Court of Human Rights in particular, the Strasbourg Court, how it impacts not only the national legislation, but also the design of the international instruments and the jurisprudence of the Committee on the Rights of the Child. Thank you very much for listening.
Thank you very much, Mr. Guđbrandsson. Very inspiring. I think, yeah, on the same time, I mean, we long way to go, but at the same time, these evolution really are very encouraging. We are, as Isabella Mastropasqua, we are now trying to set up the condition for a Barnahus or a system that go towards Barnahus in Naples, and we are very inspired by the experience. We realize the complexity, but at the same time, the need also in terms of consistency with international legislation. And this interpretation is very important for us. I would like to see probably more judges also from the side of Italy in getting involved in this debate. But yeah, we are trying to push in a way. An event like this are really serving the purpose of reflecting, but also soliciting reflection in terms of the system. So thank you very much. I think I will go straight to the presentation of the Special Representative of the United Nations Secretary General on Violence Against Children, Najat Maalla, and leave some space for the discussion after that. I think that there are some questions floating in the chat that probably Daya can propose after the intervention of Mrs. Najat Maalla. She's the Special Representative of the Secretary General on Violence Against Children, was appointed as the Secretary General appointed as a Special Representative, Dr. Maalla, in 2019. She's a medical doctor in pediatric and has over the last 3 decades devoted her life to the promotion and protection of children's rights. We have very inspiring speakers today. Was a member of the Moroccan National Council on Human Rights and founder of the non-governmental organization BITI, the first program addressing the situation of children living and working in the streets of Morocco. From 2008 to 2014, she served as United Nations Special Rapporteur on the sale of children, child prostitution, and child pornography. Dr. Majid also worked as an expert consultant for national and international projects, strategies, and policies relating to child rights promotion and protection. She holds a doctorate in general medicine from the University of Rabat, a specialization in pediatric and neonatology from the University of Bordeaux, a master human degree from the Human Rights Institute, Geneva. She is the recipient of numerous awards and honors for a strong commitment to protecting the rights of the child. And we are very happy to have you here. You have the floor, please.
Thank you, dear people. Dear distinguished participants, dear friends and colleagues, it's a real pleasure to participate in this event together with the distinguished speakers I just heard before. The contribution of the European Court of Human Rights through its extensive case law to the enhanced protection of the rights of the child, including child victims of crimes, has been essential over the years. My contribution to today's discussion will focus on strengthening the cooperation between child and social protection, law enforcement, and the judiciary for safeguarding child victims of crime. Let me start by saying that a life free from violence and effective access to justice are two basic dimensions of children's rights and two key components of the 2030 Agenda for Sustainable Development. The Agenda 2030 cannot be achieved unless all children have equal access to justice without discrimination, and justice in its broadest sense, embracing not only criminal, civil, or administrative justice, but also social and environmental justice, meets the rights and needs of children as enshrined in international and regional human rights standards. Justice systems play a pivotal role in preventing, protecting, empowering, and providing redress to children who are victims of crimes while holding the perpetrator of such crimes accountable. However, we all know the decision and action of justice professionals, from police to prosecutor, judge to lawyers, may also have a direct impact on the safety of child. They may also cause unnecessary stress and trauma, leading to a secondary victimization of the child, as highlighted by the previous speaker. And as we know, children who are victims of crimes face long-term physical and mental health problems. They often face stigmatization within their communities, within their peers, or fear reprisals against them or their family. While confronted with the justice system, they must go through the lengthy and complex proceedings. They may be interviewed by different professionals and at different stages of the process, often several times. While already traumatized, they may have to face their perpetrator, leading to a secondary victimization of a child. They are often left without support of trusted adults or professionals with the necessary skills and knowledge to secure a child-sensitive environment within which children can be safeguarded at all times. A comprehensive and a cross-sectoral approach to safeguarding child victims of crime, therefore, demands justice institutions and bodies to conduct child and gender-sensitive criminal investigation and proceedings. This includes the right to be treated with inherent dignity and respect, be protected from hardships, and be provided with the opportunity for effective and meaningful participation in the proceedings. This is even more relevant in highly sensitive cases, such as cases of child sexual exploitation and abuse, or child trafficking, or with respect to victims who may be in more vulnerable situation due to their gender, disability, sexual orientation, belonging to ethnic minorities, among others. This requires the engagement and cooperation of justice actors with child protection agencies, health and mental health and education professionals, and other social and community services to assess the specific needs and vulnerability of child victims of crimes. That's why we need to define justice system more broadly, referring not only to judicial organization and processes, but also to professional and services whose interventions are related to those of the law enforcement and courts. This includes a wide array of services such as victim support, advocacy, economic assistance, counseling, hotlines and helplines, safe sheltering, education, health and mental health, legal and social services, and professional, well-trained, including not only judges, magistrates, prosecutors, police, and cyber police, or lawyers or paralegals, but also psychologists, forensic and medical staff, social workers, among others. Such services need to be provided in an integrated and coordinated manner, reflecting the indivisibility and interdependence of children's rights. We know that despite the progress made in many countries, there are a number of challenges that still need to be addressed. Let me share some reflection in this regard. The important role played by social workforce professionals, as well as the need for effective cooperation between child protection agencies, law enforcement, and the judiciary need to be recognized in law and practice. There is a need to invest in social workforce, increase the number of trained and skilled social workers and psychologists, and provide them with necessary means and working conditions to perform their duties. A meaningful multi-stakeholder approach requires justice sector actors, from judge to police to legal aid provider, to work together and with key actors of child protection and social systems. We know considerable benefits can be gained where agencies and professionals establish close working relationships and share information, which is not always the case. In this regard, the adoption of protocols for different stages of the justice process among entities that provide services to child victims of crime, as well as interdisciplinary joint training and capacity building, can help develop a culture of meaningful cooperation and assistance. Investments needs to be made in cross-sectoral services for the care, support, and recovery of child victims of crimes and their families, including psychosocial rehabilitation services and remedies, which remain a challenge in many countries. Cooperation between professionals must be secured not only at local and national, but also at transnational levels. Many forms of crime against children are facilitated by more and more organized transnational crime and evolving technology. Safeguarding child victims requires, therefore, enhanced cross-border cooperation, including information sharing, mutual legal assistance, and cross-border partnership among all professionals, not only from the justice system, but also from the protection system and the ICT operators. This transnational cooperation is relevant more than ever, given the huge displacement of children due to increasing humanitarian crises in various regions, including in Europe. And we know that these children are more at risk to be victims of trafficking, of sale, of illegal adoption, of sexual abuse and exploitation, of forced labor, enrollment in criminal and armed groups, among other vulnerable risks. Legal empowerment of children and their families is critical to ensuring access to justice and to redress, to make sure that no one is left behind. And most importantly, all effort to strengthen cooperation between professionals must be informed by children's experiences and views. Children must be consulted and heard to ensure that justice systems interacting with child victims of crimes are truly child and gender sensitive. There are many good initiatives in various countries for strengthening multidisciplinary and multi-stakeholder approach and provision of integrated services where police, prosecutor, medical staff, psychologists, and social workers are working in the same location under one roof, as documented by DCI and also as just illustrated by the previous speaker. But such initiatives need to be scaled up by the government and sustained in the long run, and not only at the capital level, but also at the local level, and mainly in the most poor and remote areas, to make them accessible to all children and mainly the most vulnerable. And here Finally, I come back to the crucial role of the European Court of Human Rights and encourage it to continue providing guidance through its case law regarding the assistance that should be provided to child victims of crime, as it has done on several occasions and in its most recent case law. Thank you for your attention.
Thank you very much, Najat. It's very, very comprehensive and is really complementary to the other intervention. We have really a very interesting framework, and we have some time also for questions to our guests. Daya, would you like to take over for these? I saw some of the question to Mr. Guđbrandsson, and maybe there is something else. We have some time and to proceed to the closure of the seminar in probably half an hour. So, Daya?
Yes, thank you, Pippo, and thank you to the two speakers, Bragi Guđbrandsson and the Special Representative, Ms. Majid, for the very rich presentations. I have seen, as people mentioned, two questions that came up while Mr. Guđbrandsson was speaking, but I would say they are possibly even relevant for both speakers. So I would say, let's begin with both of them. I will pose them together, and then we'll give the floor back to you. And I encourage the other participants also to share with us your comments and questions. So Mr. Nestor from Romania asked about restorative justice approaches, which is a very important issue, still very much under development and discussion in the context of violence against children in the home. And he's asking specifically about cases of sexual violence at the hands of the parents or someone in the family home. And the question is about your views, if you consider it possible to take recourse to restorative justice approaches in these contexts, if you see room for considering these approaches to be in the best interest of the child, not only before any proceedings, but possibly also after a judgment has been handed down. And he's also asking about mediation approaches in child protection cases. So these are several questions in one, and a very interesting field. And also our dear colleague Turid Heiberg asked a question that is an important one, which often comes up in child protection cases regarding the situations where parents may withhold consent to an investigation into the case, including, for instance, also to medical examinations and other measures that may be needed to gather information and evidence in a case. She's asking about situations where the court would decide to limit the parental responsibility in order to proceed with such investigations, even in the absence of the parental consent. And if you have any recommendations on how to approach such cases in the future. Thank you.
Do you want me to start, perhaps, Daya? Yes, okay.
Yes, thank you. I didn't say this. Please go ahead. Thank you.
Yeah, first with regard, if I take the latter question first from Turid Heiberg. Hello, Turid. It's nice to see you on the screen. With regard to children's rights to seek confidential medical services, I think one needs to bear in mind the sort of gradual rights that the child should be assumed to receive in accordance with the child's general development. Many European states have introduced this right to confidential medical services with, a lower age range, like 15 or 16 years of age. Children have the right to seek medical services independently from the carers and even without knowledge of the parents. And this, I feel, is extremely important. However, one must realize, of course, that the parents, they are responsible for the health and well-being of the child. So it's not unreasonable that they do exercise this authority. However, this authority may never be a hindrance in the investigation of suspected child abuse issues. And I think most states have some sort of legislation that allows for intervention of the authorities in this context, although the legal framework may differ very much from one country to the next. But I don't think you will find in many states that the parents can actually preclude such medical or legal investigation, as if it is the decision of the child protection authorities or the judicial authorities that such a medical evaluation should take place. There are, I think, in most states, if not all, legal provision that allow for such medical intervention. But my short answer is that I think states should consider lowering this age, so go down from 18, perhaps down to 15 or 16. Now, with regard to the question from Romania on the restorative justice in child sexual abuse cases, I must be pretty frank in that I am not a great believer in that approach. I am so old in this branch that I remember the time when this was the default procedure. It was child abuse was seen as a manifestation of a dysfunctional family. So what you needed to do is to correct this by family therapy, etc., etc. But we have learned that this doesn't work, to put it bluntly. I'm not opposing to and arguing that family therapy is not important or should not be carried out, but you cannot, unfortunately, ensure the safety of a child victims of sexual abuse within the same household as an adult perpetrator. You can do this in cases where the perpetrator is older sibling or another child. You can work with the parents to ensure some sort of programs or way of living of the family to ensure that the child victim is never at risk. But when you're talking about adult offender, adult perpetrator of sexual abuse, I don't recommend that this should be tried. And this is a long-standing experience. I base this assertion on long-standing experience and research. Unfortunately, those individuals who are sexually molesting their children, although some of them may be receptive to therapy and you can make progress, and I think you should offer therapy and support to all of the perpetrators. However, you cannot ensure the safety of the child, and that is our primary concern. Thank you.
Daya, may I? I just want to react very quickly because I think Bragi, if I am pronouncing it well, already responded to the question. And I will start by, this restorative justice approach, in the case of sexual abuse of children in the circle of trust and its family. So I just don't want to remind that sexual abuse of children is a crime, and just to never forget. And this is one. The other thing, we have to be very, very careful, regarding, giving the priority to the community, to the family, instead of, taking into account all the issue of child protection and child best interest. So for me, it's impossible to discuss about restorative justice in case of sexual abuse in the circle of trust, because we have to take into account that these children are duly impacted and with long-lasting impact, and it's a dysfunctional family and will allow that to continue. And what made me having many concerns, and you know, in many countries, you are seeing a huge increasing of societal tolerance to many forms of violence. So something is going wrong if we are going to continue like that. So I think our first goal is to make sure that the child is safe, that he's not feeling guilty, that he's not stigmatized, that it not fear, have no fear from reprisal. And we know that in many countries, children sexually abused in the circle of trust, in families, in church, in sport, and so on, have many fear, are stigmatized, and feel guilty for years and years. So I think here it's not about, you know, we don't need to have mediation. And we have here to make sure that the legislation is duly protecting children. I think this is really important. It doesn't mean that we don't need to have support to family, to work on family and to work closely with family. But the priority is the best interest of child and his safety, because he can't rebuild himself. He is feeling guilty all his life, and if he's not really being seen also as a victim and not really as a kind of people who and in the same time we have to be very careful to put on the shoulder of child, what do you want? Because if it's father or it's it's really, we have to be very careful about what we are doing. And I am really against this proposal. Restorative justice we can have in other cases, but not in this case. Regarding, you know, the other question, when the families are didn't want really to have all this investigation, I think first, sure, you need to convince them and to make sure that they are on board. But I agree also with Bragi, and you have many countries who did it, because it's when it's really we are speaking about children victims of crime. So I think here it's important to do it in a confidential way, and at the same time, you know, how we can more and more, you know, informing parents and family really to be involved. But we have to do it because it's a role also of justice. Justice is not only fighting prosecutor, it's protecting children, and I think this is really important to keep it in mind. Over to you.
Thank you very much. I also have a question. It's a very general one, but I was wondering, I mean, you are in the field of children rights since so many years, and I have the impression that there is really the need of an advancement. You're talking, of course, about best interests, integration, intersectoriality, and these things that can make children rights as a living thing. Since we have a lot of professional, different kind in this seminar, what do you think is an element that is missing that we should reinforce in order to revive, you know, this convention and use it as a logic, that is before, during, and after an event like child sexual abuse or child on violence? I know it's a very naive question, but I really feel the need to ask how we can revive and put into practice this orientation. What is the element that is hindering this? I was referring before to the presence of judges, for example. I mean, we are still very beyond, you know, this kind of understanding. So a suggestion, since this seminar is for inspiration, I really would like to ask you something that could provide an orientation, of course, not a definitive answer, but, you know, what is the suggestion you would give to all the professionals that are here and that eventually will be contacted also with what has been discussed here? Yes, please.
I will start, you know, because I was involved, you know, in my country and in other countries, how we can really strengthen the justice system and also involving all the key stakeholders, judge, prosecutor, magistrates, and also lawyer, law enforcement, social workers, and so on. And I think what is really important is to embark them in all this process, because in many cases, they forget that they have a strong role to protect and promote children's rights, and also to change the mindset. And to do that, it's not only about providing guidance, it's good, but how you involve them in the process of really building and owning this guidance and to make things change in their practices. And I think this is important. It takes time, but it is possible. And we have good examples, worldwide. This is one. The other thing that I think it's important, we have judges who are champions, in defending, in promoting, children's rights, and making sure that they could be civil rights, and also criminal, investigation and criminal protection and so on. And I think we need also to give more and more the floor also to the judge, and who are championing that and showing that it's possible. And I met a lot, even in challenging countries. So I think we need to have more and more of them, not only as a recipient of what needs to be done, but even despite, constraints and challenges, you have some who are really, really using, the convention. Really, and I just remember one case in my country when the judge used the constitution to use the DNA for children born from rape, and it was a jurisprudence, and it was crazy. And the judges that, despite not having money and not having tools, who are visiting children in institution and promoting and seeing the child safeguarding. So we have, but we need to do it more and more, and to see them also, and not opposing child protection to child justice, but making also child justice becoming part of the child protection system. Over to you, people.
Bragi, do you have?
Yes, I could make some general comment if I have understood you correctly. I feel generally that the most important thing when we are sort of looking at the issue of child sexual abuse in particular is to look at the level of consciousness of society, the level of awareness, because we are all professionals as the public. We are all responsible for our children, and to ensure that the children are safe and that they can exercise their right in the different systems. So the first issue there is awareness. And to be able to create a social awareness, one needs to disseminate information constantly and reliable data on the prevalence, on the nature of this phenomenon, and information on how to be on alert. Children need to be informed, of course, as well. We need to engage in dialogue with our children about the risks involved in all areas, both within the circle of trust and outside. So I think we need to work on this on many levels. And very importantly, we must realize that child sexual abuse is not only a judicial issue. I could even argue it is more importantly a health issue, and I'm here talking about the mental health. That is the whole aim of our intervention, is to ensure that the child victim receives the appropriate healing and support and therapy. Whether we can manage to prove the case in court or not is almost a secondary issue. At least we must ensure that the child victim has access to therapeutic services without any conditions of meeting the burden of proof. Like in many societies, the child is not entitled to therapy until the judicial process is over. Not only because it may possibly affect the judicial process, but also because the case hasn't been proven. So we must stop thinking about the issue of child sexual abuse in strictly legal, under the legal framework. We must see this as a responsibility of us all as a society and as parents and as professionals in different sectors, and we want to collaborate. We should collaborate together, and whatever we do, we must do it together, the different professions. I don't know if this provides you with any of your...
Yes, thank you. Sure. Thank you very much for your answer. And I think it's a cool to probably interpret the Convention on the Rights of the Child in a multidisciplinary sense. No, it's not just about law, but it's about substance. And we know very well that the Convention was built across disciplines, not just legislative things. So, and I was very, very touched by the recall of social work as a very strong mandate on that. And all professionals, I think, have to probably perceive this principle and legislation as an entry point to redefine their mandates. So thank you very much for your answer. I don't know, Daya, do you? I think you have a more practical question than I did about the process in Naples. I mean, some question raised from this process where we are trying really to put together all the agencies and create a common mind, no, in a way. Daya.
Thank you, Pippo. And I have to say, while you were talking, another question came in through the chat. So if we may conclude maybe and see if we manage to address both these questions. We have Juliana Senre asking about, again, coming back to the discussion on restorative justice approaches. And she is wondering about your views regarding mediation or restorative justice in situations where a person who has been a victim of child sexual violence in childhood has reached adulthood and at this adult age would like to consider restorative justice or mediation. And if you have maybe any experience with regard to such cases, that would be very interesting to know. If I may add immediately, my question regards, as people said, our experience in the territory of Naples, where we were very much struggling with the coordination between the criminal proceedings and the civil proceedings, because in fact, the focus of the discussion on the Barnahus and the brilliant cooperation approach in this institution is often very much focused on the criminal proceedings. And we were struggling with questions concerning how to ensure that the data and the evidence that is gathered on the child in the criminal proceedings could possibly also inform any civil proceedings, for instance, where we're talking about the limitation of parental responsibility, considering, for instance, questions of data protection. And we do have, in fact, in Naples, a very interesting cooperation protocol between the two prosecution services dealing with the criminal and the civil aspects. So we would be very curious to know from you if you have any recommendations or experience from practice on how to coordinate these different proceedings. Thank you very much.
Thank you, Daya. If I may start. Well, this issue of confidentiality of personal data is always a central theme. For example, when building a Barnahus or working multi-agency or interdisciplinary. And we know that in most of European states, there are strict confidentiality rules with regard to personal data. The first thing I want to highlight is this, that in cases of child sexual abuse, in most cases, you have at least one of the parent that is not engaged in the abuse. And that parent is capable of giving permission to the different agencies to make use of the personal data and to share the personal data for the purposes of criminal investigation or the child protection intervention or medical intervention. Secondly, there are in the legislations of most European states positive provisions that allow the certainly the judicial system to access personal data in form of as a part of criminal investigation, the child protection authorities as well. But by seeking the consent of the non-offending parents, in most often is not a problem. However, some states have found cause or reasons to pass specific legal provision on this. For example, when Denmark decided on implementing Barnahus nationwide, they made amendments to their law on social services, allowing the social services to share information and allowing the criminal justice system to share information with the child protection. So it depends on states how this can be best sort of arranged. But I think everywhere the non-offending parent is in a position to give consent to sharing of information. Now, with respect to the question by Ms. Sandra, I thank you very much for posing this question. My brief answer is yes, there is an entirely different situation when we are talking about adult survivor of child sexual abuse. That's totally different issues, and it can have a great healing impact to engage in victim needs offender programs in these situations, and even with older children as well, in some time following the abusive event. My answer earlier was basically on the child and in the circle of trust that the child should not be put in a position to be in contact with his or her perpetrator during childhood. During the adult years, this may be a part of restorative justice or mediation, can be part of the healing process, and this must be decided on a case-to-case basis. And of course, it is the survivor or the victim who alone can, in fact, tell whether this is feasible or not. Thank you.
If I may, I will very shortly complement the point. Regarding the second point, survivor really and mediation between, survivors. They could be survivor or victims of sexual violence, but also of terrorism and so on. And I saw also the other question. It's up to them as adults, and I think it could be part of the healing process. This is done in many cases, so this is different. But we have to be also careful that many of them didn't want to have it. It's really up to the adult survivor to do it. But in the same time, as physicians, we need to really bear in mind also the impact on, facing and discussing again about this, trauma, because it's a long-lasting impact, and mainly when the perpetrator is not recognizing it. And so we have to really see how we can. And also, I want to come back to your question, Daya, regarding coordination. And since in the beginning in my speech, I was telling that it's missing, that we have not this coordination. When we are speaking about justice, it's more about criminal and legal framework and so on. But we are not speaking about the role of justice, the civil justice, the administrative justice, and mostly the social justice, because you have more and more, forms of violence or children of vulnerabilities that are due, to lack of family care, lack of access to basic services because of poverty, because of discrimination, because of lack to identity, because, difficulties between parents and so on. And I think here, when we are speaking about justice, and it's our role, all of us, to start thinking also about the role of justice in protection and in promoting children's rights. And here it's really important. And here why it's important to have in this coordination system, to have the social sector and the child protection sector, and involving also the community base, and in mainly regarding just regarding humanitarian crisis worldwide currently, what is going on. The problem is, okay, they are at risk, but they are facing many other issues. And here we are speaking about social justice, and this is really important. And regarding Barnahus model, and just to let you know, Bragi, that I am going to go to Iceland in 3 days, so with meeting your minister Asmundur. So I think we have also to make sure that this model, and I just came back from Romania, Greece, Austria, I think what is important is not copy-paste the model, is most about the approach. And I think when we put together judge, social worker, medical staff, educational staff, you know, all those lawyers, just to have a common understanding about what means violence. So sorry, for example, child labor for many judges is not violence, you know, and regarding, you know, lack of access to education or corporal punishment or many things. So I think we need to make sure that the front line persons who are dealing with children and their caregivers are really reviewing our capacity building and empowering skills to put them on board. And it was highlighting in the beginning by equation, if you are strong social worker, well-trained, knowing very well, you know, the administrative, civil and criminal procedures, short, they are not going to become lawyers, they could really become this ad hoc administrator that really accompany children and their caregiver within all these processes. It will be the link, he will be or she will be the link. And I think here it's important very to strengthen this social workforce, and also to invest in legal empowerment of children and their caregivers. This is very important because they have to know what are the law, what are their rights, and how, when they can seek, you know, redress regarding remedies. We need this counterpower. Over to you.
Thank you very much. Thank you very much. I think we have a lot of material to process after these couple of hours spent together. Thank you again for being with us today, to participants and to our distinguished guest. Yeah, I think we are heading to the end of this conference. I would like just to remind something before giving the floor to Snezana, that is leading from the Internet and Law Foundation, this ECtHR project, just you know, to give us some information about what is there and what we are going to do now. Just let me remind you that a fundamental rights agency just recently produced a very important handbook on European case law on rights of the child, So, I mean, I invite you to, since Najat was suggesting, you know, the idea of reinforcing this common glossary, you know, in a very deep sense. I think this is a very important material that was produced by the Fundamental Rights Agency and is available on their website. Snezana, please give us some information about you know, the ECtHR project and you know, where we are going, and I think it's the best way to conclude this important event. Thank you
very much, people. Hello, everyone. It's really a pleasure for me to be part of this very final event of our ECtHR project. First, I would like to thank our DCI colleagues for organizing this very high-level event and seminar. Thank you to both of our speakers who are still present, and of course, to the one who already left. It's really a pleasure, and your time and contributions are really much appreciated. So just a brief overview of the project and what we have managed to achieve during the last 28 months, which have been really struggling and challenging time, taking into account the COVID pandemic and not only. So ECtHR 2 has been designed to build upon the results which have been already achieved during its predecessors, ECtHR 1, with the main aim to bring even more light in terms of how the Directive 2012-29 of the European Union should be implemented in practice. So basically the main achievements of its predecessors have been to focus on ensuring the practical implementation of the individual needs assessment methodology, which have been developed during the first project, and to contribute to making it even existing the national systems even more compliant with child victims' rights and their needs. The main partners, as you probably already know, is Law and Internet Foundation from Bulgaria, the Ministry of Justice from Italy, which we are really grateful to, Defense for Children Italy, Southeastern European Research Center from Greece, and the Romanian Center for European Policies from Romania. We have achieved a lot despite the COVID pandemic. Unfortunately, some of the events have to be carried out in hybrid mode. Some of them went completely online, but we have managed to organize some of them face-to-face. So the overall numbers are like 16 meetups in all 4 partner countries with more than 780 participants in total, 4 twinning visits in countries beyond the partner ones, namely Albania, Portugal, Hungary, and Sweden, with over 88 participants, 3 international workshops with more than 762 participants, 5 virtual events with over 160, which we consider as a great success, taking into account all the circumstances. And really through this intensive consultation series at both national, bilateral, and international level, the project has really succeeded to strengthen already the existing partnerships and networks and foster new ones within the partner countries and across borders as well. We have been constantly updating our Child Protect platform, which we'll share in the chat in a bit. And of course, last but not least, I'm really happy to share with you that the gamification platform has been also integrated on our platform, and it's up and running since October 2021. It's one of the probably most prominent outputs under the umbrella of the project. The entire consortium has been working really hard to achieve it and to deliver it on time. The idea behind the platform is basically to create an environment to enhance the professionals' capacity in more practical implementation of the individual needs assessment methodology, and to try, let's say, their knowledge and skills in a more case-based orientated manner. I'll share the link for the gamification in the chat as well, not to overwhelm you and to try to be as brief as possible. And finally, since the rationale behind the project has been really recognized by all engaged professionals and partners for more than 4.5 years now, and they have been very positive about the conducted activities, not only the events, but also the research and everything that we have been doing as a consortium, we really have been encouraged to keep working on the topic related to ensuring children's rights and towards improving professionals' capacity in the field, along, of course, with your support. If you don't show up to our events and if we don't have the support of our valuable speakers, it will not be possible. So yeah, thank you again, and we'll keep in touch in the next few months with follow-ups and what you can expect from us. Even though the project is ending, the platform will be up and running with updates, and yeah, we hope to see you in other occasions as well, and to keep working together on that really important matter together.
Thank you very much, Nesana, and thank you also to the Internet and Law Foundation, which leaded all these operations. We have a long-standing cooperation, and I think it's one of the contributions that we are providing to the general debate and action on the issue. Thanks again to Bragi Guđbrandsson for being with us. It has been an honor, and to the other guest. Najat Maalla has to leave because she had a flight. Thanks to all of you for your time and your interest. We will share on the website the slides and the recording of the seminar, and we will keep connecting with you in trying to really innovate this approach to children victims of crime and under the orientation provided an intelligent and multidisciplinary and integrated approach to children's rights. So thank you very much again. It has been a pleasure. Thanks also to our staff, to the interpreters, to the Ben who's followed up the technical aspect of all of this. I think we had no problem at all. So I wish you a nice rest of the day and I hope to see you soon. So.